To today's web conference on the future of the SEC's Administrative Forum, presented by Foley and Lardner, LLP. Hello, everyone. My name is David Pulio, and I'm with Foley and Lardner's Marketing Department. On behalf of Foley, I would like to thank you for joining us today. Now, before we begin, we do have a few housekeeping announcements for the program today. Today's program will last approximately 1 hour, followed by a short question and answer session. We encourage our attendees to submit written questions during the program. Please type your question into the Q&A widget, which is open on the left-hand side of your screen. We will respond to written questions at the end of the program. The webcast console you're looking at can be completely customized, and you may resize or move any of the windows that you have open, including maximizing the PowerPoint presentation on your screen. If you experience any technical difficulties during the presentation, please visit the webcast help guide by clicking on the help button below the presentation window. It is designated with a question mark icon. The PowerPoint presentation will be available on our website at Foley.com in the next few days, and you may also get a quick copy of the slides in the resource list widget, which is open on the left-hand side of your screen. As a reminder, today's program is being recorded and will also be available on Foley's website in the upcoming days. Foley will apply for CLE credit after the web conference. If you did not supply your CLE information upon registration, please send it in an email to my colleague Brooke Radford at bradford@foley.com. To be eligible for CLE, you will need to be logged into and viewing this session on a computer and answer a polling question announced sometime during the program. As a final note, if you are seeking Kansas, New York, or New Jersey CLE credit, you are required to complete an attorney affirmation form in addition to the polling question that will appear during the program. A code will be announced during the presentation. Please email the form, again, to Brooke Radford at bradford@foley.com following the program. Now, I would like to introduce our speakers for today. With us today, we have Mark Mandel, a partner in Foley's Security Enforcement and Litigation Practice. Mr. Mandel is a former chief of the New York office of the U.S. Securities and Exchange Commission's Division of Broker-Dealer Enforcement, with over 20 years of experience as a private practitioner focusing on complex securities-related litigation and enforcement. Joe Edmondson is a partner in Foley's Securities Enforcement and Litigation Practice. Mr. Edmondson focuses primarily on defending securities litigation and enforcement proceedings brought by the U.S. Securities and Exchange Commission, state regulators, FINRA, and other self-regulatory organizations. He has over 20 years of experience in commercial litigation and regulatory investigations. John Friedman is a senior counsel in Foley's Securities Enforcement and Litigation Practice, with experience representing clients in a broad range of complex, high-stakes commercial litigation, as well as in enforcement proceedings before the SEC and various SROs. And we're also pleased to have with us today as a guest speaker, Mr. Jeff Coverdell, a managing counsel for Wells Fargo. And I'd like to turn it over to our presenters now and wish everyone a wonderful presentation.
Well, thank you, David. This is Joe Edmondson. I'm going to kick us off with an overview of what we're going to talk about today, and then do a little level set so that we all start at the same place. Our topics today are split up among the speakers. I'm going to cover the SEC Enforcement Division's choice in bringing cases administratively as opposed to filing in federal district court. And then Mark Mandel is going to talk about the history of unsuccessful challenges to the SEC's administrative program based on due process and other fairness-based concerns. John Friedman will then talk about what we refer to as the new silver bullet, the appointments clause theory, that for the first time seems to have some traction in these constitutional challenges to the SEC's administrative forum. And then Jeff is going to lead us in a roundtable discussion of various issues that arise from the discussion. And we ask you to prepare your questions as well and join the discussion at the end. We'll deal with those questions. So let's talk about the choice of forum as between the SEC's administrative forum and federal district court. Let me start by saying this is an incredibly fast evolving topic. It's been very fascinating and interesting even for our panel here to keep up with events as they've unfolded. Even as we've been planning this web conference, things have happened. Oops, looks like we lost a slide here. Hold on a minute. Even as we've been talking about preparing to put on this conference, we have been inundated with current events. And this is a very current topic. Some might call it a trending topic. Everyone's talking about it, speaking about it. Cases are pending on appeal that challenge the administrative forum. New challenges presumably are being filed or prepared even as we speak. And it does appear that all the attention that is being drawn to these issues is putting the SEC under some pressure to defend itself. This is a topic that's not without some degree of controversy, depending upon which side of the table you find yourself. And while I don't expect anything that your panel here will say is going to be unexpected or particularly provocative, other than in an intellectual sense, we do wish to emphasize that the comments of the panel are personal to the panelists and don't necessarily reflect the views of our law firm or, in Jeff's case, his company. So, setting the stage for what we're going to talk about here, and a lot of this is off slide until we get to Dodd-Frank, but just a bit of history. So when the SEC decides to bring an enforcement action, as most of you know, it has two choices. It can proceed administratively in its own forum, or it can file judicially in a U.S. district court having jurisdiction over the defendant. In the administrative context, most cases that the SEC brings are settled proceedings. They're not litigated at all. And the same is true of cases that are filed in U.S. district court. The majority of those cases are also settled proceedings. And a settled proceeding is simultaneously filed, and orders imposing the sanctions or other relief are entered by the commission or by the court respectively. So in the administrative context, these cases, the settled cases, are never touched by an ALJ, and they're not really litigated in any way. So when we talk about challenges to the administrative forum, we're talking about cases that are filed and litigated before an ALJ. We're not really talking about the settled cases because they just don't raise these same issues. For decades, as many of you also probably know, the SEC has been able to seek monetary penalties administratively against only regulated entities and individuals specified by statute. This before 2010 is what I'm leading to. But those regulated entities such as broker-dealers, investment advisors, investment companies, other registered entities could be subject to civil money penalties under administrative actions. And if the SEC wanted to go against non-registered entities for monetary penalties, it had to go to federal court. And the most obvious example of this is insider trading cases where oftentimes the perpetrator is not an SEC registrant. Now, this is not to say that the SEC did not also proceed on occasion against regulated entities and individuals in federal court, because it sometimes did. It sometimes would go after those entities and individuals administratively and then seek a monetary penalty in federal court as an adjunct, or it might bring the entire case, even against a regulated entity, in federal court, even though it was entitled under statute to bring that case administratively. If the occasion warranted it, we believe, the enforcement staff might conclude that the remedies provided administratively were not sufficient. The SEC might not want to seek a C&D, cease and desist order, instead opting for a federal district court injunction. the perception was, and often was, that the injunction was more serious than a cease and desist order. And practically, an injunction might trigger collateral consequences, both hard and soft, that might put some regulated entities out of business. And that was oftentimes a tremendous lever to be used by the SEC in negotiations against someone to get them to settle. So all this is to say that the SEC has long been used to a situation where it has a choice of forum, and this is nothing new to the Enforcement Division, at least in certain circumstances where the statutory authority overlapped. And when Dodd-Frank was enacted in 2010, however, it opened up more choices for the SEC. And specifically, Section 929 PA of Dodd-Frank for the first time gave the SEC the ability to seek monetary penalties in cease and desist proceedings, even against entities that were not regulated by the SEC. Not surprisingly, on the heels of the implementation of Dodd-Frank, the SEC began publicly announcing its desire to use the administrative forum more frequently. Now let's compare the forums really quickly. Mark is going to get into this in a little more practicality and link it up with some of the challenges. But just as a level set, again, in an administrative proceeding, you have ALJs presiding as finders of fact and finders of law. In federal court, you have independent Article 3 judges. And of course, the difference between this is important. ALJs are, at the SEC at least, are employees of the Commission. They are hired through a civil servant system. They are subject to certain forms of employment law, tenure, and other provisions that employees have. Whereas independent Article 3 judges are appointed for life and do not have all the trappings of power that one associates with a federal judge. On the discovery front, in administrative proceedings, there is generally very limited discovery. There are certainly no depositions, and there are other avenues of discovery. For example, the SEC does have to provide its regulatory file, which, by the way, is a reason why the SEC sometimes does not want to go administratively if they don't want to turn over the file, since that's not necessarily the case in federal court under the Federal Rules of Civil Procedure. Obviously, jury trial is a big difference. No jury trial before an ALJ, of course, whereas you have a right to a jury trial in federal district court. The SEC rules of practice do not contain rules of evidence, so hearsay and other forms of evidence are admissible in administrative proceedings that would not be admissible in federal court. And then the success rate is something, now this is talked about quite a bit out there in the bloggers and the commentators and the press. And the success rate, and also including judicial opinions, higher success rate for enforcement, nearly 100% in the administrative forum, a lower success rate for enforcement in federal district court, at last count, approximately 61%. Now, let me pause on that for a minute, and as a testament, I'm going to let the slides catch up here. We're having a bit of an issue. We should be. Okay, so we should be back one more slide. Okay, so in a testament to how quickly things are moving in this area, just this morning on Law360, an article is out citing the scholarship of Urska Velikonja from Emory University in an upcoming article in the Cornell Law Review. Professor Velikonja is unpacking some of the SEC statistics that folks are citing. And while the article in Law360 does not talk about success rates per se, the study does. I was privileged to attend a Cornerstone Research conference last week where the draft of the study was discussed in some detail. And there's reason to believe that the cited statistics that the SEC uses and others are using here are not valid on a number of reasons. I'm just going to pause on that. I'm not going to unpack that entirely because we could take another half an hour just to do that. But I guess beware of the statistics. I will have a slide that goes into that just in a little bit more. And then the appeal to the commission. So an administrative proceeding is appealed to the commission. Now, the commission is the same commission, however, that authorized, unless there was a change in the commissioners between the time that the action was authorized and to be brought and the time that the appeal arises. It's going to be the same commission that authorized the appeal, the institution of the proceeding, and that's an interesting situation where you have someone who thought there was sufficient grounds to bring the proceeding, then having to deal with the appeal of it. And then the further appeal from the commission is to the U.S. Court of Appeals for the D.C. Circuit, where the D.C. Circuit will use a substantial evidence standard to deal with the appeal, and perhaps impose, in the right case, Chevron deference to the agency's interpretation of the law. And of course, in federal court, you have the ordinary appeal that everyone is familiar with. So the premise that the SEC is making an increased use of ALJs, putting aside for the moment whether or not the data is valid on that, there's certainly been some articles and some studies that have pointed to the fact that the use of administrative proceedings is up. And when you get your slides home to look at them at your leisure, you can click on these links and see some of these articles. Now, why would the SEC want to be using these ALJs more frequently? Well, Mark's going to talk about the litigation advantage, but I just want to add a couple of other things that are maybe a little softer, a little more policy oriented. The litigation advantages of an administrative proceeding for the SEC as compared to federal court, including most importantly the threat of getting to a hearing very quickly due to time limits that were also imposed by Dodd-Frank, provides the SEC with a huge leverage to induce settlements. Not that they didn't already have one, but this makes it even that much more powerful. Secondly, we shouldn't lose sight of the fact that there's another policy initiative afoot at the SEC. The SEC is increasingly desiring to have settlements that include the respondents to admit the charges. And nevertheless, there are some cases that are still, and maybe even the majority of cases that are still being decided on the basis of settlements that neither admit nor deny the charges. Well, you'll remember in 2011, in the Citigroup case, Judge Rakoff was asked to approve in federal district court a settlement that included a neither admit nor deny settlement, and he refused to do so. Now, luckily, for those of us that favor neither admit nor deny settlements, the Second Circuit vacated that decision and very strongly said that the SEC has a choice of remedies and a choice of weapons in its arsenal and can use these kinds of settlements. But nevertheless, in 2013, the SEC is still saying that they're going to require admissions in a certain number of matters. All right, now let's go back to the statistics. The devil is in the details, of course, as to the statistics. We have to be careful that when we're counting administrative proceedings, we're not counting settled proceedings, orders instituting proceedings, making findings, and imposing sanctions, or OIP MFISs. We should be counting only litigated proceedings, because those are cases where the ALJ was involved. And many of these administrative proceedings that are being counted as successes for the SEC are follow-on actions. So when there's a criminal case or a federal court case, the SEC might go back to its administrative action forum and seek a bar or other sanctions against a regulated individual or entity, and those would count as successful administrative proceedings when there is essentially no defense or practically no defense to those proceedings. There are also other kinds of cases, such as Section 18 cases and other cases that are strict liability violations. Those cases are also like shooting fish in a barrel. So, those cases aren't necessarily shouldn't necessarily be part of the analysis. So the better question is, when the SEC makes a meaningful choice of forum, which forum is it choosing? And on that note, I won't go into it in great detail, but in May of this year, the SEC actually published guidance entitled "The Division of Enforcement's Approach to Forum Selection in Contested Actions." And nothing in there will be surprising, except for the fact that the SEC really trumpets the expertise of its ALJs. And that has created a bit of a controversy between the SEC on one hand and Judge Rakoff in the Southern District of New York on the other hand. In November of 2014, Judge Rakoff gave a speech where he criticized the SEC for taking too much control over interpretation of the securities laws by using ALJs. And the SEC basically says, well, our ALJs are expert. And that raises the question that I raised in the slide here is, are they really expert? Now, no one will doubt that some of the long-serving ALJs like Judge Follick and Judge Murray are pillars of securities jurisprudence. I mean, they know these laws as well as anybody, and they know how to apply them. But what's surprising is that many of the newly hired ALJs don't have any experience at all in securities, and their background is in Social Security Administration hearings. That troubles some people, and people are questioning whether those are the right qualifications to be made. And this is especially poignant if, going back to that appeal issue, if the SEC begins to claim, as it sometimes does, Chevron deference to its administrative adjudications in light of its experience in interpreting its own statutes, and that could be potentially troublesome on a couple of levels. First of all, oftentimes the initial decisions of ALJs are not reviewed at all by the Commission. Under the statute, if the initial decisions are not challenged or taken up sua sponte by the Commission, they become final automatically. And in that sense, are they really, formal agency actions expressing the views of the five commissioners, or are they the decisions of a SEC employee? And sort of teeing up some of these issues for discussion by Jonathan and Mark. At the end of the day, you have five commissioners who are vetted based on their qualifications, who would, I would argue, be experts under anyone's definition, more or less. But if those 5 commissioners don't actually issue the decisions, then are the decisions really the decisions of an expert agency? So with that, I'm going to turn it over to Mark to talk about some of the challenges and the perceived unfairness of the administrative forum.
Thanks, Joe. This is Mark Mandel from New York. And as we were discussing, the administrative proceedings clearly offer the SEC a home court edge, and they really limit an individual or an entity who is subject to an administrative proceeding very limited rights when you're charged. So where else can you spend a number of years being investigated by the SEC and then find yourself in a forum where your rights are essentially none other than to show up and, like the Wild West, start firing questions at people whom you've never had a chance to take a deposition of? You have no opportunities to issue subpoenas to get written discovery. And like everything else, it's stacked heavily in favor of the Division of Enforcement from day one. And then, of course, you have to add to that the fact that you're showing up in front of a judge who is on the very same payroll as the Division of Enforcement. On top of that, those decisions, as Joe was alluding to, get reviewed in the first instance by the SEC. So with no rights to move to dismiss, to narrow the case, to do anything, and usually having been subject to many years of the SEC's investigation, which generally generates millions of pages of documents, thousands of pages of testimony transcripts, your counsel, who's representing you, has the daunting task of trying to hunt through a massive amount of information that has been generated in the course of the discovery that the SEC is taking in the investigative phase, and have to synthesize that and present compelling arguments in your defense. And since the rulings are final decisions that are made by the ALJs that are appointed by the SEC rather than the federal judges and the juries, it makes it a very scary prospect for individuals who are confronted with an administrative proceeding. I recently had the opportunity to represent an individual who was in the industry for over 40 years and had a perfect record as a financial advisor, and unfortunately found himself as the subject of an SEC investigation which lasted a number of years. While he wanted to go to the mat with the commission and vindicate himself as the day drew near, and as he began reading more and more about the opportunities for a respondent in an administrative proceeding, he began to shy away from the challenge. And it was all because of the limited opportunities he would have had in order to conduct discovery and do all the things that one would do in a federal district court proceeding in a civil litigation. Next slide. To make matters worse, when you're in an administrative proceeding, the federal rules of evidence, which is designed to exclude unreliable evidence, do not apply. Hearsay testimony can be, and frequently is, freely admitted if it could show any light upon the controversy. And again, if the SEC prevails, as they frequently do in these settings, then the individual is left with an appeal to the SEC before they can even pursue judicial review for the first time before a court of appeals. Finally, even at the Court of Appeals, you have to remember that there's substantial deference given to the SEC's credibility determinations and fact-finding that is made in the underlying process. So in short, the defendants have complained that in these in-house courts, the SEC truly acts as prosecutor, judge, jury, and the first line of appellate review. And it's not unlike going to a casino where the casino has its finger on the roulette wheel and tilting it in one way or the other. It is clearly a stacked deck. Next slide. Now, prior to the 2010 enactment of Dodd-Frank, which gave the SEC a number of additional weapons in its arsenal, there were challenges to the SEC's administrative form, which essentially raised constitutional issues sounding in lack of due process and equal protection. But these challenges were by and large rejected for obvious reasons. Courts were pushing those who challenged it to conclude the administrative process before they would take up any arguments. With the advent of Dodd-Frank, however, there has been additional ammunition that was provided to the respondents to mount a more serious challenge. Next slide. Judge Rakoff, who most of us are very well aware of in the Southern District of New York, who has obtained a number of headlines in some very high-profile SEC cases and is not one to shy away from controversy or to disagree with the SEC where he sees fit, made a number of public statements expressing his skepticism with respect to the fairness of the SEC form post-Dodd-Frank. And in a case involving Rajat Gupta, who was a director at Goldman, involved in the Galleon insider trading string of cases, he actually ruled in favor of Gupta, who challenged the SEC's administrative form and succeeded, had his case actually moved into federal court. Now, as a footnote to that, Gupta went into federal court and ultimately did lose, but I assure you that he must have felt that at least he had his day in court because he would have had all access to the federal rules of civil procedure, discovery, and the federal rules of evidence. Judge Rakoff was a little bit miffed, I think, at the SEC, if you look at the decision. And he wrote, a funny thing happened on the way to this forum. We should be on the next slide. On March 11th, the SEC, having previously filed all Galleon-related insider trading actions in this federal district, decided it preferred its home turf. And what Rakoff did was he noted that there were 28 or so other persons and entities who were accused in very similar fashion by the SEC of trading on inside information. Yet, in this instance, it was decided by somebody at the SEC that an administrative forum was the appropriate place to try this case. Well, Judge Rakoff didn't have anything or didn't want anything to do with that. And the decision is difficult to parse, but there were a couple of arguments, one of which seemingly was the driving force, which was in that case, the SEC was seeking penalties under Dodd-Frank for conduct that predated the enactment of Dodd-Frank. So the judge seemed comfortable with linking that fact to the fact. Many commentators have stated that the results were more result-oriented, if you will, and that may not have been a bona fide basis to prevent the SEC from proceeding in an administrative forum. Now, one of its colleagues on the bench in the Southern District of New York, Judge Kaplan, in a case involving Wing Chow. Chow, if any of you have read The Big Short, Chow was featured in The Big Short as a collateral manager for CDOs, and it wasn't a very flattering depiction of Chow in The Big Short by Michael Lewis. But Chow also was one of a handful of people who were involved in the CDO investigations who found himself in an administrative proceeding and desperately wanted to get out and tried very hard to do so. But Judge Kaplan found that the court lacked subject matter jurisdiction to hear an action to enjoin the SEC's proceeding on constitutional grounds. Next slide. And he essentially made two constitutional claims, and his claims were not unlike other claims that had previously been made but rejected. The first was that the SEC administrative proceeding against him violated due process for a number of procedural reasons, including the administrative law judge's failure to adjourn the proceedings after the SEC produced 22 million documents, and the failure of the ALJ to apply the federal rules of civil procedure. I was involved tangentially in the Chow case, having represented a witness And I had spoken with counsel who was representing Chow, and he would tell me that every day he would make a number of objections at the administrative proceeding, and they were numbering in the hundreds, and every day the administrative law judge would overrule his objections, but if the SEC were to object, the same thing would happen. And he also explained the difficulties involved in trying to get up to speed factually and synthesize the evidence, if you would, that was garnered during the course of a many years long investigation. And he said it was just an impossibility and very difficult. The administrative proceeding, the second argument that Chow raised was that the proceeding itself violated his equal protection rights because, again, similar to what Rakoff had picked up on 28 insider trading cases, all in district court, this one now is an administrative proceeding. That doesn't seem fair. That's not equal protection under the law. Chow tried to take advantage of that argument as well because there were other nearly identical collateral managers who had proceedings brought against them, but yet they were in federal district court. Next slide, please. Well, Judge Kaplan, in finding that he lacked the subject matter jurisdiction, noted that Chow's claims amounted to an as-applied challenge, essentially that it was just specific to Chow. And then the court left the door open by saying His Honor would more likely sustain jurisdiction in a facial challenge, a claim that an administrative scheme is unconstitutional in all issues. In all instances. Next slide. The decision conceded that other challenges to the SEC's administrative proceedings may yet succeed because application of the Thunder Basin factors involves case-specific determinations. The court ruled only that it lacked jurisdiction to hear the constitutional challenges against the SEC in this particular case. So again, the door is left open by Judge Kaplan. Unfortunately for Wing Chow, he did not get to proceed into federal district court, but other litigants now were able to take advantage of not only what was decided in Gupta, but with the door ajar by Judge Kaplan, there was still a glimmer of hope that there was something to be accomplished by contesting the administrative forum. Next slide. These two decisions and others that began being filed in and around the same time period and more recently have become a springboard for a flurry of litigation and appellate litigation concerning the challenges to the administrative proceedings. And the successful arguments to date seemingly revolve around Article 2 of the Constitution. And without further delay, I would ask that Jonathan Friedman pick it up from here and walk us through the Appointments Clause, among other things.
Thanks, Mark. So the Appointments Clause is the basis for the successful challenges to the SEC's use of ALJs. And for starters, I'll give a little context here on what this issue is about. The Appointments Clause is Article 2, Section 2, Clause 2 of the U.S. Constitution. In essence, it addresses, the text is on the slide in front of you, and it addresses how certain officers must be appointed with respect to what are sometimes referred to as principal officers. The Appointments Clause empowers the President of the United States to appoint them with the advice and consent of the Senate. With respect to inferior officers, so-called, the Appointments Clause empowers Congress to allow by law lower-level officials or inferior officers to be appointed by heads of departments. It does not address, as will be relevant, as is relevant in these cases, how employees, regular employees, must be appointed. And as context, the purpose, the Supreme Court in other cases in the 90s, in other contexts, addressed the purpose of the Appointments Clause and explained that it is more than a matter of etiquette or protocol. it is among the significant structural safeguards of the constitutional scheme. And, of course, the Constitution carefully enumerates which powers are allocated to which branches, and the Appointments Clause protects the Constitution's structural integrity by preventing the diffusion of appointment power. Okay, statutory authority. While Congress could have provided by statute for a specific appointment process, they instead laid it out more generally under the Administrative Procedures Act, explaining that each agency shall appoint as many administrative law judges as are necessary for proceedings required to be conducted in accordance with Sections 556 and 557. Assuming that ALJs are inferior officers, which the SEC, of course, does not assume, their appointment must also be consistent with the Appointments Clause that we just talked about and must be made by the head of the agency. So the head of the agency, that's the language in the Appointments Clause, and the Supreme Court has addressed who the head of the agency is in the case of Free Enterprise Fund v. PCAOB, in which the court held that the SEC is a department and the commission itself, not the chairperson, is its head. For purposes of the Appointments Clause, the takeaway is that any inferior officer appointed by the SEC must be appointed by the commission itself, not merely the chairperson. The problem that arises for the SEC is that the SEC's ALJs, while arguably inferior officers, and we'll get more into that, are not appointed by the head of the SEC, by the commission, but rather they are hired pursuant to an ordinary civil servant hiring process, just like other SEC employees. In particular, they're hired through a joint effort of the U.S. Office of Personnel Management, the SEC's Office of Human Resources, and the SEC's Office of Administrative Law Judges. Again, not by the commission. Okay, so that brings us to the first case to address this in a way favorable to the defense bar, the breakthrough case of Hill v. SEC out of the Northern District of Georgia from just this past June. The Hill court addressed two primary questions. First, are SEC ALJs inferior officers? And if so, does their appointment violate the Appointments Clause? With respect to whether they are inferior officers, this was the key disputed issue in the case. And the court explained that whether they rise to the level of inferior officers rather than mere employees depends on whether they exercise, quote unquote, significant authority. Not the clearest phrase, but the court concluded that where ALJs hear evidence, make factual findings, adjudicate formal legal proceedings, and impose sanctions, they are in fact exercising significant authority. And the Hill court was also persuaded by, among other points, a 1991 Supreme Court case, Freytag v. Commissioner, which held that analogous special tax trial judges were inferior officers. With respect to the other question, whether the ALJs were appointed by the commission, this was not a disputed issue before the Hill court because the SEC there conceded that the ALJs were not appointed by the commission. The court in Hill held that it was likely that ALJs were inferior officers appointed in violation of the Appointments Clause and granted a preliminary injunction enjoining the ongoing administrative proceeding. The court also pointed out that while this constitutional flaw apparently existed, it had an easy fix that the SEC could adopt. The Commission could simply go back and appoint the ALJs itself. And Jeff will, when I'm done speaking here, address whether the SEC accepted that invitation, but you can probably guess what the answer is there. This decision is now on appeal to the 11th Circuit. Judge May also issued a second consistent ruling in the case of Gray Financial Group, Inc. v. the SEC. There, the court likewise enjoined the SEC from proceeding with an administrative action. The court again found that ALJs are inferior officers and that the defendant was likely to win on the merits of the argument regarding whether the appointment violated the Appointments Clause. Okay, that brings us to the Southern District of New York, where there have been a couple recent cases addressing this question. The Duka v. SEC case is an ongoing case before Judge Richard Berman, and Judge Berman ruled on August 12 that the SEC's administrative forum was likely unconstitutional under the Appointments Clause of the U.S. Constitution. He also gave the SEC an invitation and an opportunity to address this issue, but the SEC did not take him up on that invitation, and the decision is now on appeal to the Second Circuit. Just this past Thursday, this is in the relatively breaking news category, Judge Berman denied the SEC's request to stay the injunction. Judge Berman held that the SEC will not, in the court's view, be able to persuade the appellate courts that the ALJs are not inferior officers. He pointed out that the holding will not interfere with their ability to prosecute claims because the SEC has other ways of doing that, including, by the way, bringing suit in federal court. The order also, interestingly, discussed a suggestion that has been in the news, among other places, that ALJs have been pressured to return verdicts for the SEC. And Judge Berman urged the SEC to conduct a full investigation of that possibility. Okay, as Duka is on appeal, the Second Circuit's view is forthcoming. There is a split on a related legal issue of whether federal district courts have jurisdiction to hear constitutional challenges to ALJ proceedings before a final agency decision. Judge Berman in Duka concluded yes. Judge Abrams in the Tilton decision, also in the Southern District, concluded no, there is not jurisdiction. And just last Thursday, the same day that Judge Berman declined to stay the injunction, the Second Circuit granted a stay of the Tilton administrative proceeding, which decision had gone the SEC's way. So last Thursday was not a good day for the SEC. Okay. In the interest of time, I'm going to skip over some of the background details on Tilton, but that is there for you on the slide. Meanwhile, in the Seventh Circuit, the circuit court there has gone the other way on the SEC's side in the case of Bovi v. SEC. there, Bibo, the defendant, made two constitutional arguments. One, an argument about Dodd-Frank being facially invalid, and the second, the Appointments Clause argument that we've been discussing. The court there did not consider either constitutional argument, but rather affirm the Bibo District Court's finding that the court lacked jurisdiction to hear the challenge. So the Seventh Circuit there was lining up with Judge Abrams in the Southern District. And the idea there was that the SEC administrative proceeding in which Bibo was a respondent had not yet concluded, and only once the administrative proceeding process concludes, at that point, Bibo could pursue jurisdictional challenges through the statutory review scheme. In other words, the Seventh Circuit held that Bibo had to wait for the SEC to take action against her or not, and then and only then present her constitutional objections to a federal appellate court on appeal of that final decision. This Bibo decision came down, as I mentioned, on August 24th. So when Judge Berman issued his recent decision last Thursday, he actually addressed the Bibo decision, expressed his disagreement with it, and discussed some of the same issues, discussed this jurisdictional issue again. Judge Berman explained, quote, "The SEC argues unconvincingly that a party in Ms. Duka's shoes must patiently await the denouement of proceedings within the administrative agency. But Second Circuit precedent appears to refute such a notion." And then he quoted a 1979 Second Circuit case which held that to require appellants to exhaust their administrative remedies would be to require them to submit to the very procedures which they are attacking. Okay, so that's the Bibo case. As you can see from these variety of decisions, there seems to be a potential circuit split brewing, both on the issue of whether district courts have jurisdiction to hear an immediate challenge, and also on the issue of whether on the merits ALJ proceedings are invalid under the Appointments Clause. The chart on this slide lays out a summary of the decisions that we talked about, and I will now turn it over to Jeff Coverdell to discuss how the SEC is responding to all of these constitutional challenges and the decisions from the courts that have been handed down. Over to you, Jeff.
Thanks, John. This is Jeff Coverdell from Wells Fargo. I think it's clear from all three of the speakers that have already spoken that at this point we don't, as we look at the public pronouncements in the cases, we don't see the SEC responding by laying down, or we don't see any cracks in the armor, frankly. There's, with the exception of them admitting that the SEC itself does not appoint the ALJs, there's been no admission which might show that they're trying to find a way out of this other than sticking to their guns. They're obviously defending on every front, as John just said, in the federal district courts and on appeal. So any adverse rulings, they're proceeding with appeal. And obviously, we can see, if you look at the slide, the matter of Raymond J. Lucia, we can pretty much see directly from the commission earlier this month their view as they laid out pretty specifically. And as you read it and hear it, you can sort of see them addressing some of what the courts have been saying. That case was an SEC opinion, the whole commission opinion, on September 3rd, in which Lucia Companies and Mr. Lucia were charged, and it was relating to essentially their representations about a backtesting strategy of their buckets of money retirement wealth strategy. And I think we can all get behind buckets of money. But the SEC in this case did not agree, the ALJ did not agree that in the representations made were proper. So it was on appeal both by Lucia and also by the enforcement staff. So significantly there, the Commission upheld the challenge under the Appointments Clause, which Lucia made. And Lucia asserted that the ALJ in the underlying hearing was an inferior officer under the Appointments Clause and obviously had not been appointed by the Commission or a head of a department. So the division asserted that if he was an employee, there was no violation of the clause. So in defending itself and in finding that there was not a violation, the Commission relied very heavily on the Landry versus FDIC case, which is the D.C. Circuit from 2000. That case concerned ALJs at the FDIC who would oversee administrative proceedings to remove bank executives. And the Landry court there held they were employees rather than inferior officer. And so the Commission sort of latched on to Landry and said its touchstone for determining whether the adjudicators are inferior officers is the extent to which they have the power to issue, quote, final decisions. That was what the Landry court latched on to. In that case, the FDIC ALJs would do things like take testimony, conduct trial-like hearings, rule on admissibility of evidence, have the power to enforce compliance, and so forth. But they can never render the decision of the FDIC, which is what the SEC really latched onto in its opinion here in Lucia. The Commission says, thus, their ALJs function very similarly to the facts that we see in the FDIC case or the FDIC hearing officers in that decision. So they note that in the cases of the SEC's matters, these are not final decisions either. And they basically try to distinguish the Freetag case, which John talked about earlier. Freetag is very much inconsistent, which is what Lucia argued with the position the Commission's taking. Freetag versus Commissioners, a 1991 Supreme Court case involving tax court special trial judges, where in that case they were found to be an inferior officer. So the way the SEC distinguished Freetag, again addressing the way that the courts have come down on the other side of this matter, they said that the SEC ALJ decisions are reviewed de novo, just like the tax court was required to do. They said that the tax court special trial judges were authorized by statute to render final decisions. So in that case, the tax court, they say the tax court judges are rendering the final decisions, whereas here they were going up to the entire Commission for final approval. They said that the tax court and its judges exercised a portion of the judicial power of the U.S., including authority to punish contempt by fine or imprisonment, which SEC ALJs, they point out, do not have that kind of authority. And there's interesting footnotes in that decision, or in the opinion, where the SEC notes that their ALJs are treated by Congress as employees, and they distinguish the many places where the federal securities laws and regs will refer to them as officers or hearing officers. So they, if you read the opinion, really have unleashed on every front in an attempt to refute all of the arguments. There was an even more recent decision, Timbervest LLC, where that entity also raised before the Commission the constitutionality and fairness of the administrative proceeding. And in that case, interestingly, the full Commission overruled the ALJ's decision in a couple of respects, including imposing a bar on Timbervest, but then reducing disgorgement and staying sanctions. So that was the SEC is clearly, the Commission is active in responding publicly to the arguments that John laid out. So what the SEC is not doing, as John alluded to, it definitely has not accepted Judge May's invitation to fix this problem by itself as a Commission appointing their own ALJs. It's also not simply having the full Commission vote or even seeking some sort of fix, which the legislature could do, obviously, and appoint Mary Jo Whiter, the chair of the Commission, the ability to appoint ALJs and perhaps even retroactively. And obviously a possible concern here is that the Commission doesn't want to acknowledge any potential constitutional defect while they have all these appeals that John laid out running, and because it could have consequences perhaps retroactively. So in our remaining time, we wanted to sort of turn to a roundtable discussion here with some questions that you may have in the audience and that certainly if the panel has discussed among ourselves. So we're going to kind of run through these here with our panel. So question number one, What do we expect the SEC to do, if anything, to try and fix this? And I think, Joe, were you going to try to take a shot at that one first?
Sure. Thanks, Jeff. I agree with Jeff. I can't see them doing much of anything while these appeals are still pending. What we don't know is someone could easily find out if they did the research, but it might be a little taxing to go around and find out how many new cases are being filed challenging the jurisdiction or challenging the constitutionality, and to see how much of a avalanche this really is unfolding. I mean, I guess we're sort of predicting an avalanche as people see that there's some traction here, but if the avalanche doesn't come, the SEC might not be under as much pressure as we think that they will be. But let me just, in just 30 seconds, there are some proposals here that are very creative that people are talking about, if you haven't heard about them. The U.S. Chamber of Commerce came out with a proposal that creates this incredibly complicated mechanism for respondents to challenge the choice of forum by bringing sort of motions practice to force the SEC to choose the forum that's most applicable to the matter, given the issues, given the types of fact-finding that needs to be done, et cetera. Chairman Cox is advocating a removal statute. That would be a legislative solution that would allow litigants to by right, by statute, automatically remove the administrative case to federal district court. Andy Vollmer, who is the former general counsel of the SEC, takes Chairman Cox's one proposal one step further, or a step towards refinement. Removal only in cases that allege fraud. So there's some fixes out there, that maybe the SEC needs to start thinking about in the event that this does get these challenges do reach the substantive stage. And maybe not so much on the appointments issue, because that's more structural, but the issue that Mark talked about, which is more the equal protection and the due process, if those issues start getting traction, they may need to remake the system a little bit. Jonathan, with respect to those appeals, how long do you think it's going to take for those appeals to wind their way through? How long are we going to be in a straitjacket?
The short and honest answer, Joe, is we don't know. But the data point we have is that the SEC has already filed its appellate brief in Hill. That was on August 4th, and they will wind their way forward from there. I don't expect any decisions from the circuit courts imminently, but it could be as soon as a couple of months from now, or it could easily bleed into 2016.
All right. Well, thanks, Joe and John. Our second question for the panel is administrative proceedings that are already in process. What should a litigant do? And I'll maybe start us off on that and then open that up to the panel as well. I think hearing from all three of our speakers before me, it's quite clear that there are a number of different things going on. Mark talked about Gupta's limited success, although ending up in federal prison is probably not full success. But in terms of looking at what you do if you're already facing an administrative form, I think you're going to have to, besides calling your lawyers at Foley here on the line, you're going to have to assess the landscape that applies to you. There's certainly pros and cons in trying some of the challenges we're talking about here today. I think, just thinking as an in-house counsel, we'd be looking at what Gupta's success was based on. And as you read it, there's a lot of fairness from Judge Rakoff that bleeds through the opinion. In that case, you've got so many others, I think it was 28 others who were referred already through federal court with the same charges, and it clearly stuck in the judge's craw. And as my colleagues have said earlier, Judge Rakoff has particular views which are maybe not shared by every court around the land. So I think you would want to look at what your particular facts are and whether you've got arguments that certainly you can make the appointments argument, the constitutionality argument, and as John noted, we don't know how soon we'll get better guidance on how that's going to play out. But you can also look at the facts in your case for fairness and try to maybe lay it against the Gupta case and those types of cases. You can also obviously look at the forum you're going to be in when you're seeking that sort of relief, because I think it's quite clear from reading things publicly that there's a lot of creativity going into where these challenges might lie. And so you can certainly explore and taper, I think, based on your own particular circumstances. The timber vest decision is interesting because the SEC said in that decision, which came out, I think it was last week, Congress gave the Commission authority to initiate administrative proceedings as well as to bring civil actions in federal court. The Commission's choice to use either or both of those means to enforce the securities laws as a matter of broad agency discretion. So you can expect a firm fight from the SEC in trying to get outside of the forum, outside of the administrative forum if you're exploring it. But as Mark noted, the playing field is certainly not equal in either case. So having said that, maybe I'll throw it open to the other three panelists to see if you've got additional comments about it. And silence by all jury members means we'll go to question number 3.
At this time, actually, we'll be reading the CLE code for this program. If you're in need of CLE credit today, please enter the 5-digit code into the poll question that is currently on your screen, and I'll be reading that code right now. The code is G as in golf, 9, J as in Juliet, Y as in Yankee, 4. That's G9, J, Y, 4. And again, if you are seeking credit for this session, please enter that code into the box on the screen in front of you and click Submit. For those seeking Kansas, New York, or New Jersey CLE credit, in addition to answering this polling question, you will need to complete an attorney affirmation form and return it immediately following the program. A copy of the form can be found in the Resource List widget, which should be open on the left-hand side of your screen. And one final time for the code, that is G as in golf, 9, J as in Juliet, Y as in Yankee, 4. All right, and at this time, the poll is closed, and I will return this to our panelists. Thank you very much.
Okay, thanks very much. Let's move on to question 3 then, which is, are prior SEC administrative orders subject to vacation on constitutional grounds? And Mark, do you want to handle that?
Yeah, and I think it's and I'll try to be as quick as possible because I know we're running out of time, but this is a subject that could probably be the basis for a full program. Obviously, the SEC studied decision not to take any action in order to confer arguments on those who are challenging the administrative forum, to me signals that they are indeed very concerned that if these cases take on and get traction, that the others who were subjected to the same processes and procedures may, in fact, be successful in attacking them subsequently and having final orders perhaps vacated. This is a very difficult question, and it will be subject to a lot of litigation if, again, the decisions play out and are actually adverse to the Commission. And I think we should stay tuned because there's a lot developing in this space.
Thanks, Mark. And our final question for the panel will be, what effect will this increasing uncertainty have over the SEC's settlement leverage and pending investigations? And John, you want to start on that?
Sure, Jeff. I think it will have a material effect, actually, for 2 primary reasons. First is that the SEC will have less leverage to demand aggressive settlements without the guaranteed backstop of adjudication within the home court advantage they enjoy before these ALJs. And the second reason is that while this constitutional dispute remains open and different courts are resolving it different ways, and defendants are therefore apt to litigate it, the staff may be gun-shy about proceeding to litigation that will inevitably entail a fight over the constitutionality of this fundamental SEC system of adjudication. So for those reasons, I think it could discourage the SEC from proceeding to litigation, and given that both sides will be aware of that, I think it will give the SEC a bit less settlement leverage than it ordinarily has.
The other panelists want to weigh in on the leverage in pending investigations question.
Jeff, this is Joe. Let me just bring that back to something that I talked about during my initial portion, and that is that, you know, back in the days pre-Dodd-Frank, you know, everyone seemed to be scared of the prospect of having a federal court injunction issued against them. And there's maybe a bit of a dichotomy. If you think you're going to settle the case, then you probably want to see if you can steer that settlement towards the administrative forum, because the sanctions are sort of less draconian appearing. You know, you can argue that a C&D is really nothing more than an agency-issued injunction with a few less bells and whistles on it. But because of the collateral consequences associated with injunctions, you might want to steer away from that in a settled case. But if you're going to litigate, you probably want all the advantages of being in federal court, and those advantages probably outweigh the risk that you might end up with an injunction. So, you know, knowing whether you're going to settle or not is probably a big part of the decision-making process.
And thanks, Joe. Are there any questions? I don't see any that are appearing online here. Are there any questions from our group that they want to have the panel address? David, maybe you can let us know if you see any coming in.
I do not currently, so we'll keep that Q&A running for the duration of the next couple minutes while we've got the program going here. But that is all that we have at this point. I would like to say, though, that at the conclusion of the program, a brief evaluation questionnaire will appear for our attendees, and we would appreciate them to take a minute or two to give us the feedback for the program today so we can continue to put on even better programs. So thank you for that.
All right, so we don't have any questions in our queue here, so I'll turn it back to you, Mark. My moderator duties will be hereby completed, and I'll have you finish this up.
Well, once again, thanks everybody for bearing with us. The program ran exactly what we thought it would, to about an hour and 15 minutes. So thanks again for your participation, and we look forward to chatting with you in the future.